attorney-client privilege and the corporate witness. I'd like to introduce our speakers. Complete biographies are included with today's PowerPoint. Kay Baxter is a founding partner of Swetman, Baxter, Massenburg, and practices in its New Orleans office. Her litigation practice focuses on the defense of toxic torts, occupational disease, environmental claims alleging personal injury, property damage, as well as various areas of construction litigation. Amy Danna is licensed in Texas and practices with the Clary Firm, where she focuses in the areas of complex civil litigation, personal injury, and general corporate and small business counseling. Daniel Wills is a partner at Swanson, Martin & Bell, where he concentrates his practice on insurance coverage litigation, maritime law, and appeals. We thank Kay, Amy, and Dan for their work on today's program. Panelists, the floor is yours.
All right. Thank you, everyone. This is Kay Baxter, and we'd like to welcome you all and thank you all for attending today. We're pretty excited about this presentation. Dealing with a corporate witness is something that I have to do on a regular basis. And obviously the aspect of emails, text messages, electronic communications, and now social media is going to play a really big part in all of this. And it's things we hope that we're able to give you today, information that you definitely can use in your practice, and I think could easily become a seminar for in-house, for your firm, because everyone needs to be aware. Your clients need to know, your associates, your partners, everyone needs to know how this will impact their practice. And with that, I'm going to turn it over to Dan.
Thanks, Kay. As everyone knows, we are talking about the attorney-client privilege as applied to corporations, to electronic communications, and to social media. I get to start with the boring topic, corporations. As you all know, on slide 6, the attorney-client privilege applies to confidential communications between an attorney and a client regarding legal assistance for that client. And the privilege does apply to corporations. But if you represent corporations and you're like me, you find yourself often asking whether a communication or a document is in fact privileged. And it's not easy. The courts themselves, although they've set forth a couple of tests, which we'll discuss, admit that it's done on a case-by-case, and I would say communication by communication and document by document basis. It might help in addressing the issue of whether the privilege applies to take sort of a big picture view. And remember that courts are trying to balance two objectives with the attorney-client privilege. On the one hand, we want discovery of the truth, which of course the privilege impedes by definition. On the other hand, we want everyone to have good legal counsel, which requires the privilege. And that's what courts are weighing. The privilege has been around since the Roman Empire. It's always been applied to the United States. Until the late 50s or early 60s, U.S. courts applied the privilege to corporations in the same way that they applied it to individuals. But around that time, some courts started questioning that position, believing that the privilege as applied to corporations was too broad. They raised various objections to the privilege, which you should keep in mind when you're deciding this issue with your clients. First, some courts pointed out that one of the purposes of the privilege is to avoid self-incrimination for an individual. It's a personal right, and therefore shouldn't apply to corporations. Courts also pointed out that the confidentiality that exists between an attorney and a client doesn't necessarily exist in a corporation where information is flowing freely amongst all the employees there. Courts also were concerned that corporations would try to apply the privilege to facts from witnesses who work within the corporation. And of course, witness factual testimony isn't privileged. And finally, and related, some courts worry that corporations would manipulate the privilege. For example, run embarrassing documents past counsel so that you can say they're privileged. So eventually, during the 1960s and 1970s, courts did in fact narrow the privilege, and that resulted in what is called the control group test. And you can see that at slide 8. And that limits, in the corporate context, the attorney-client privilege to communications between management, basically. Privileges between those who have authority to make decisions for the corporation and to take actions on behalf of the lawyer's advice. They are in the control group, and only they hold the privilege. However, in 1981, in Upjohn versus United States, the Supreme Court unanimously rejected the control group test. In that case, Upjohn became concerned that some of its managers overseas might have been giving bribes to foreign governments. To look into it, Upjohn, with counsel, developed a questionnaire that it sent to various managers overseas. In the ensuing litigation, the government sought those questionnaires. Upjohn claimed privilege. The Supreme Court, in rejecting the control group test, said that it was too stringent because it stops the free flow of information within the corporation. The court noted that many facts, much information comes from lower down in the corporation, and therefore the privilege should also apply to employees. The court also said that the control group test created uncertainty. I think they were wrong there because it's actually a bright line test, and what we're left with now is courts developing the common law for the subject matter test, which we'll get to. Upjohn is binding, of course, on all federal courts, and some states have adopted it: Alabama, Arizona, Arkansas, Colorado, Nevada, Oregon, Texas, and Utah. The next question then, given that the privilege applies to corporations and their employees, is whether the privilege applies to former employees. There's your list of how the circuits have applied Upjohn to former employees. Almost every court does apply the Upjohn subject matter test to former employees. The problem you're going to have is in figuring out what actually is protected. The general rule now developed by courts for former employees is that the privilege applies if it concerns information that was obtained during the course of that employment, and if the information was privileged then and it remained privileged during the employment. So if you're talking to a former employee about communications they had while they were employed that were privileged, they're still going to remain privileged. But how far does that go? If we look, say, to Upjohn as an example, if there had been an employee at the time who had helped develop the questionnaire and decided which managers to send that to, if you're talking to that employee later after employment, all that's going to be privileged. But what if you also want to discuss with that employee the results of the questionnaires that came back after she left? Likely that is not going to be privileged. You can argue that it is, but it's a fine line, and you need to be careful. Also, if you're preparing a former employee for deposition, only the privileged material is going to be privileged, so that if you say are giving coaching tips in the deposition, that's not going to be privileged. If you talk about litigation strategy or work product, that likely isn't going to be privileged. Peralta is a good case, often cited discussing the privilege for former employees, and there's the test that you should consider with the former employee. Did the communication relate to the employee's conduct, knowledge, or communications with counsel during employment? If so, it's privileged. If not, probably not privileged. So what do you do when you want to talk to a former employee, but you're not sure what is and isn't privileged, or you know it's privileged, but you want to go beyond that? Now, obviously, you can talk about what you know not to be privileged. It'll just be available to the other side. And you're going to have to make these decisions, of course, on all aspects of litigation: interrogatories, depositions, documents from the former employee, and their testimony at trial. The safe bet is to assume the privilege doesn't exist until you have satisfied yourself otherwise. And you will want to conduct due diligence about that former employee to make your privilege determinations. Obviously, the dates of employment are going to be relevant. What were the contents of the former employee's discussions with counsel? If you're not sure which test applies, or if you're in a jurisdiction like Illinois where the control group test applies, what was the former employee's role? Does she qualify for the control group?
let me hop in here for just a second. Talk about doing due diligence with a former employee. Here's an experience I had. Found that I needed to put up a corporate witness in about, I had 2 weeks notice because I got pulled in after let's say the former attorney had some issues and had not found a corporate representative. I found a guy, former employee, I thought was great. In fact, he was. He was amazing. About 2 days before we were going for this deposition, I learned that he had been let go from the former employer when they were downsizing, and that he, in fact, had been a member of a class action lawsuit against this company that I was about to put him up to be their corporate representative witness in a very serious case. I cannot tell you the amount of dancing I did about that, but turned out that this guy had incredible loyalty to his former employer. And, of course, he was upset when he was downsized and let go. But talk about due diligence. People, I cannot recommend that strongly enough. So there you go, my war story. Continue, Dan, please.
And, of course, you'll want to determine whether the former employee is represented by independent counsel. And this really gets to the nub of it. If you're going to be dealing with a former employee, what you want is to represent that employee. And then you resolve all these potential problems with privilege. Now, there are lots of rules you have to take into account in trying to represent the former employee, but I'll say 90% of the time, I do represent the former employees. I don't if they say no, which is rare. You need to avoid soliciting, and you want the client, not yourself, to offer the representation. But in most situations, that's what the client is going to want. And it's not going to cost the client more, really, to represent the former employee. You can get the employee on your side. You don't have to worry about privilege. So have the client reach out to the former employee and offer the representation.
Isn't that where you're going to be getting this person's name anyway, from the client who will give you a list of, or you should be asking for the list of people? You're like, okay, we need a corporate representative who's going to have knowledge of yada, yada, yada. Who would you recommend? So it's coming from the client to begin with, and certainly, hopefully, they have a good enough relationship that this person will want to be. But then you have to keep in mind that sometimes there's a conflict.
Right, and obviously if there's a conflict, you have to advise the former employee. They can waive that conflict. You can't act as if you're disinterested. I mean, your loyalty is going to be to the corporation, and you can let the former employee know that. And also, Kay, as you said, with your corporate rep who didn't work out or might not.
Oh, it worked out great. It was the best. I got to tell you, it was the best corporate representative witness I have ever put up in my lifetime. Even the court reporter, every attorney there was complimenting me, but I was in a state of pure shock before I put him up.
And when you get the witnesses from the client, you're not only going to say, let's offer representation, but you're going to do what Kay did, find out what you can about each witness. Did they leave on bad terms? Is it someone who's going to be against the corporation? We just had one recently where the employee refused representation. The case went through summary judgment. The employee didn't appear, wouldn't get a lawyer, and we're afraid he's going to get a judgment against him. And when he did his deposition, he wouldn't let us represent him, and he wasn't nice, let's put it that way. So you would advise of a conflict of interest. But, Kay, Amy, do any of you see a problem with trying to represent the former employee?
This is Kay, and I'm working with that right now with several clients. When you're looking for someone with knowledge, generally they're going to be someone who is older, depending on the age of your company and how far back they want to go back. But I've had great success with it. And most of the time, I can't think of an instance where that employee said, I don't want to be represented by you. I can tell you I've had the instance where after, meeting with them, getting to know them and talking to them about what they remember and what the corporation is saying, there was a time when I had to go to the client and say, you know what, maybe either we get a new attorney for these people or you need to settle. But, you have to always be cognizant of that possible conflict. Amy, what about you?
Had much the same experience as you, Kay. The thing that we've typically run into from time to time is simply employees who don't want to be represented by anybody. They don't want to be bothered. They have knowledge that may be valuable, but it's difficult to extract that from them. And so that's the only real variant that we've run into.
Although there are times where the former employee will say he doesn't want to be represented, I'll give him my information and say, call me if you need me, and he calls when he gets subpoenaed. Not only can you avoid privilege problems when you represent the former employee, but if it's an employee who's gone and maybe isn't thrilled with the corporation, you can work with that and make for a better witness for the company, and still be fair to the former employee who doesn't have to pay for counsel. So everybody wins.
Good point. Dan, we had a question about, would this former employee, would that also cover former directors?
I don't see why it wouldn't.
Me either, because I have a situation now where I'm representing an entire board. And, of course, I did get conflict waivers signed by all, just for the purpose of making sure that all my bases are covered and that they were fully informed.
All right, Kay, I think unless there are any other questions, that's all I have on corporations and former employees. And I turn it over to Amy.
Okay, thank you, Dan. I'm here to talk to you about electronic communication and preserving the privilege. Social networking, mobile devices, instant messaging, text, tweeting, all of these and more are creating new challenges and setting new expectations for attorneys. First of all, the clients have new expectations of us in how they communicate with us. And additionally, our respective bars are beginning to have new expectations of us as well. We all remember the days when we brought our clients into the office and had confidential discussions, more often than not via landline telephone, face-to-face, through the post office. And now clients seek us out via new electronic means, and they expect us to communicate with them the same way they seek us out. And so the duty to protect the confidential information of all types is further challenged by the fact that many of the lawyers don't either understand electronic communications or they have failed to take the necessary precautions to protect them. Now, we are required by the rules of professional conduct, as well as common law, private contracts, state, federal, and international laws, and court rules. Law firms that are operating on an international basis have special considerations as well, because the attorney-client privilege isn't defined the same way in all parts of the globe. So those firms need to take a special look at what they need to do specifically to protect attorney-client privilege. In this day and age of communication that happens more frequently than not through electronic means, how does the lawyer protect the attorney-client privileged information? A couple of things that we can do to help. First of all, we can educate the client regarding the basics of attorney-client privilege. Sometimes even more sophisticated clients fail to fully grasp and understand the importance of privileged information. Clients have to learn how to avoid both intentional and inadvertent disclosures. And Kay, I think you have an example of what was probably inadvertent on the part of the client, but certainly it was intentional disclosure with the Facebook disclosure.
There have been many instances, well, of the people who like to, of course, Facebook, big right now, but they don't seem to grasp, and I think we'll go into this a little bit when I'm speaking about it, but I think it maybe has something to do with the age group. They want to do Facebook, but they don't understand that is going to have a big impact. and it will go out to people they don't realize it's going to. They can also be tagged, which is another aspect they need to understand before the company, the corporation, the witness, and our family members start posting on Facebook.
It's an important point, and I think, Kay, you're going to cover a lot more about social media in a few minutes. But for educating our clients, attorneys can do a couple of things. First of all, they can more thoroughly explain the privilege to the client, and they can also explain the risks of disclosing privileged information. Sometimes the client doesn't understand why it's a problem to disclose this information. The other thing attorneys can do is make it simple for the client. Tell the client never to communicate with counsel using an employer's computer, instant messaging, text, etc. Tell them to pick up a landline telephone to contact you or to send it in an encrypted email. And also the other thing that you can do is encourage clients to add the words attorney-client privilege in the subject line for electronic communications. And this has a twofold benefit. It's a reminder to the client when they do it that this is confidential information. And also, if it's accidentally sent to someone else, let's say the dreaded opposing counsel, then the recipient is on notice that it is categorized as attorney-client privileged information. And also, we need to keep in mind that even as we're representing, like for instance, Kay is representing the board, if they're not currently engaged in litigation, they may be at some point. And if your communications are marked attorney-client privileged, it's easier to sort through them and determine which types of communications you want to pull. There have been a couple of cases. There have been more than a couple, but we're only going to talk about a few today. The first one is City of Ontario versus Quan, a 2010 case. This was a California case. And in this case, the Supreme Court addressed public employees' rights on mobile devices under the Fourth Amendment. The plaintiff, Quan, was a SWAT team officer in Ontario, California, and he repeatedly exceeded the monthly allotment of messages allowed on his city-issued pager. So the city audited his message records over his objections, and the audit showed that many of his messages weren't work-related and that some of them were sexually explicit. So the city disciplined him, and he sued the city, arguing that the audit was an unreasonable search under the Fourth Amendment. The court assumed, without deciding, that Quan did have an expectation of privacy in his work-issued pager. However, they also found that the audit was a reasonable search. The court emphasized that Quan knew his pager could be audited at any time and that knowing whether his overages were due to non-work messages was a legitimate work-related rationale supporting the audit. So I thought it was significant that the Supreme Court, by assuming that Quan had an expectation of privacy in his pager, recognized the viability of these types of constitutional rights. However, they declined to lay down a hard and fast rule regarding mobile devices because they noted the changing technology and changing cultural attitudes towards technology. So that was a relatively significant case. And that takes us to the next case, also a California case, Holmes v. Petrovich.
I think that these slides, Amy, are a perfect example of what needs to happen for the corporation and in law firms. Everybody needs to sit down, bring in lunch, sit down and go over exactly what the expectations are for office computers, pagers, cell phones. If your office is paying for the cell phone and the cell phone service, I think you got a real good argument you're entitled to that employee's text, emails on the phone, that type of thing. These type of slides of these cases are very important, not only for your corporation client and the client, the corporate witness, but also for the practicing attorneys who will be dealing with all of it.
Agreed, and that dovetails right into Holmes, Kay. In this case, also a California case, it raised the question of whether emails sent to counsel by an employee using her employer's computer were privileged. And the circumstances are as follows. The employee had been told specifically that company computers were to be used only for company business, and that employees were prohibited from using them to send or receive personal email, and that the company would monitor compliance with its computer usage policy and might actually inspect all files and messages at any time. So the employees were told specifically that they have no right of privacy for personal information or messages created or maintained using the company computers. Now, in addition to announcing this policy, the warnings were also contained in an employee handbook that the plaintiff, in this case, Holmes, admitted that she had read and signed a copy of. So in this case, Holmes sued Petrovich for, amongst other causes of action, wrongful termination after she told her employer of her pregnancy. And so when she became concerned about her continued employment, she had sent an email from her office to an attorney and also forwarded to the attorney various emails that she had received from her supervisor. The attorney told Holmes to delete all of the communications from her work computer because her employer might claim a right of access to it. And it turns out that's exactly what happened. Holmes later resigned. She claimed a hostile working environment, and the lawsuits followed. The employer found the attorney-client email exchange on their company computer, and over Holmes' objections, they used it at trial. The Court of Appeals acknowledged that the California Evidence Code specifically insulated privileged electronic communications from waiver where people involved in, quote, the delivery, facilitation, or storage of electronic communications may have access to the content of the communications, unquote. However, they said this wasn't the case here. They said that sending emails on the company's computer was akin to consulting her lawyer in her employer's conference room in a loud voice with the door open so that any reasonable person would expect that their discussion of her complaints about her employer would be overheard by him. And so they said that any belief that she had of the privacy of her email exchange was unreasonable because of the handbook warning specifically. They stated, quote, it was unreasonable for Holmes to believe that her personal email sent by company computer was private simply because, to her knowledge, the company had never enforced its computer monitoring policy, unquote. So that's a great example of what Kay was talking about with respect to communications. And we've got another interesting case. I'm sorry, Kay, go ahead.
I was just going to say, I was trying to look at this and put it in the context of a corporate witness. And if you have a corporate witness who's using if it's the employee, I think Dan, you'll agree with me, if the corporate witness is still employee, then there is an expectation of privacy and privilege.
Yes.
But if you're dealing with a former employee who is using, let's say the corporation is being super nice, and he says, I don't have a laptop, and they say, well, here, take one of our laptops. So it's a company laptop this former employee is using, and he's exchanging emails with, you're talking about the case.
Well, in that case, the privilege may be maintained, but what I was thinking more along the lines of is an ex-employee that you're having communications with is now employed elsewhere and communicating with counsel on his new employer's equipment.
Which is excellent point, because I have that exact situation. We have a former employee that we use as a consultant. And in fact, he has testified in the past as our corporate representative. He's now employed by someone else. So the fact that if I were foolish enough to communicate with him through his work computer, somebody better know what that policy is for his new employer. And that is being said for all attorneys on the phone and any corporation. You better know who you're dealing with, not only as your corporate representative, but if they're somewhere else and they're a former former employee, what's their new employer's policy? Your policy may be different than what theirs was. So the preparation you have to do, the due diligence you have to do is just magnified by all of the electronic communication and the social media aspects of it. So food for thought. Continue, Amy, please.
Absolutely. And we have one more example that I'd like to share with the group with respect to email privacy. Again, thinking ahead to a witness who may be employed elsewhere and may be using another company's computer. And that is Stengart versus Loving Care Agency. And this is a New Jersey case. It reached a slightly different result, but the circumstances were slightly different. It also involved the ability of an employer to recover emails, this time from a company-issued laptop, a mobile device. And in this case, Stengart used her company-issued laptop to exchange emails with her lawyer through her personal password-protected web-based email account, so likely a Hotmail account or a Yahoo account, something along those lines. And then later she filed an employment discrimination lawsuit against her employer, Loving Care Agency. The agency hired a forensic expert to recover files, and they found Stengart's attorney-client emails, and they recovered those from the company laptop. And Loving Care gave the emails to its lawyers. The lawyers claimed that there was a privilege waiver because of Loving Care's written policy that, quote, email and voicemail messages, internet use, and communication and computer files are considered part of the company's business and client records. Such communications are not to be considered private or personal to any individual employee, unquote. Now, that was the written policy. The New Jersey Supreme Court disagreed with that written policy, and it held that Stengart had a subjective and objective expectation of privacy in the attorney-client emails. She had the former, the subjective expectation, because she used a personal password-protected account for the communications, and the latter because Loving Care's policy did not specifically address the use of personal accounts. They wanted it written in the policy that specifically addressed personal accounts before they were willing to take that step and allow privilege to have been waived. The court went a little bit further, and they also announced that because of the important public policy concerns underlying the attorney-client privilege, that a policy that banned all personal computer use and provided unambiguous notice that an employer could retrieve and read an employee's attorney-client communications if accessed on a personal password-protected email account using the company's computer system would not be enforced. So that was a little bit of a step out.
We've had a couple of questions that I think are important that I know come up later, but in the Stengart, when people are using, the question is, in the Holmes case, was she using a work email address or a personal email address on the work computer? Or, put it in another way, is there a difference between using work computer for a web-based email account and the company's email system? There is a difference.
In the case that we're speaking of now, she used a personal password-protected account that was web-based. So like I said before, probably a Yahoo or a Hotmail account or Gmail or whatever people use that they prefer. So that's different than using your company email address and your company account, even if your company email address is password protected.
But you need to also, if you're using your own, the web-based email as opposed to the corporation's email, you need to stop and think, is this thing being saved onto the company server?
Exactly. And so, I mean, a clear recommendation, I think, when you're dealing with witnesses who are employed at other companies and sending you email is that they don't use company equipment, even if they're sending email from their personal password-protected, private, web-based account.
Again, so many things to think about.
There are. And I think that we've talked a lot about what we can do now to educate our clients. The next thing that we need to talk about is educating the attorneys. And so the obligation of attorneys and other firm personnel, all firm personnel, to protect information applies not only to client confidential information, but also to proprietary information and private information about third parties. Comment 16 to the ABA Model Rule 1.6 recites that a lawyer must act competently to safeguard information relating to the representation of a client against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision. And we all know that every state has rules and case law addressing attorney-client privilege. And every attorney on the call today is encouraged to go and review their own state bar ethics opinion bank to familiarize themselves with that. But what we run into time and time again, especially with technology, is that the ethics rules and opinions state what a lawyer should do, but they don't give a lot of guidance on the actual steps that might be taken to preserve privilege, especially during electronic communications. We have a couple of ethics opinions available to us. There are a lot more than this. I just pulled several of them. But for instance, the California opinion 2010-179 states that lawyers risk violating their duties of confidentiality and competence if they use public wireless connections for client work without taking appropriate precautions such as file encryption, encryption of wireless transmissions, and personal firewalls. Florida Opinion 10-2, lawyers who use devices that contain electronic storage must take reasonable steps to ensure that client confidentiality is maintained and to sanitize the device before disposition. New Jersey Opinion 701, duty to take precautions is informed by available technology. So as technology changes, our duty to be informed continues to change. Lawyers should password protect confidential documents, transmit by email because it's impossible to secure the internet against third-party access. And then there's one that I haven't listed on here, an Alabama opinion, 2010-02, lawyers may use cloud computing to store client files if they keep current on appropriate security safeguards and take reasonable steps to ensure the cloud vendor uses suitable methods to protect the stored data. So here we're reaching even further and having to find out a little bit about what our vendors do to protect our confidential information.
I was looking at this and thinking again about the situation with the corporate witness. And I was thinking, okay, if your corporate witness, again, let's say, it can be the corporate witness who is still an employee, but they have a portable hard drive. And they have this portable hard drive at home because it's just easier for them to look at everything and not worry about having to get online or something like that. If they're traveling, they've got it with them. And then they become a former employee, and they still have this portable hard drive. That's something that you have, again, due diligence. What are you going to do about that? Dan, what do you think about the ramifications of having a former employee walking around with a hard drive of information?
Okay.
Yes.
Oh,
did you hear my question?
I did not.
I said, what do you think the ramifications are for having a former employee walking around with a portable hard drive from the corporation?
Not good generally, but privilege-wise, it's the corporation's privilege to waive. So
right.
anything on there that's privileged would remain privileged even if someone else saw it.
And I think also it would be information that was gathered while he was an employee. That takes us back to one of your original slides, so that the privilege would still be in place.
Right, and someone had asked a question about directing former employees not to talk to counsel, and that raises the privilege issue. And I don't think you can really do that, or at least bind them to it. But the privilege, even if they disclose privileged information, it will still remain privileged. Obviously, you don't want the other side to get it, but you can keep the privilege there too.
Stoke. All right, Amy, back to you.
Okay, I've put up one other opinion on there. I'm sure by now you've all had a chance to read it, so I won't go through it in detail, but essentially a lawyer needs to take competent and reasonable steps to ensure confidential information isn't disclosed, and so they must have the competence to evaluate the nature of the threats and evaluate the computer hardware and software that they're using to transmit confidential information. Or if they lack the competence, then hire an expert consultant. I think most of us have people that IT departments or people that we contact to keep us abreast of all of the latest updates so that we don't jeopardize attorney-client confidentiality. But bottom line is a lawyer needs to either have the competence to evaluate the potential threats to a client's electronic files and through communication, and to evaluate and use appropriate computer software to protect the information, or hire an expert to do so.
Amy,
so the question becomes,
I was going to ask, do you think that goes so far as for the attorney to question the client about their computers and what safeguards they have in place?
I think it absolutely goes that far, because unless you instruct specifically how the client is supposed to communicate with you and you've ensured that those communication lines are secure, then if they're going to be communicating with you from various places, hotels, coffee shops, et cetera, I think that it does bear some discussion, and I think that does fall under educating the client as opposed to educating the attorney. What are your thoughts on it?
I would agree with you. If we are using, if we're doing everything we can, and I think another important thing to keep in mind here is not every client corporation is a Fortune 500 or a Fortune 50. Some of them are mom and pop corporations that we're dealing with, and certainly they're not as sophisticated as others. So our duty certainly goes to instructing them, and I've gone so far as to have my IT people assist my clients with their computer issues for the very purpose of making sure that we have protected our communications and that they are not inadvertently sending out information that they, should not be and did not intend to be sending out.
Agreed. And so we have to ask ourselves, what can we do? Generally, we can start by evaluating the risks associated with both internal and external threats. Internal threats, they can include the use of computers and other electronic devices containing protected information by firm personnel. Those personnel might be insensitive to the need to protect the information or simply not understand it. Sometimes they even engage in improper activity with firm information. And then external threats can include spyware, malware, hackers, depending on what kind of case you're dealing with. Some of that information could certainly be at risk by spyware and hackers. There's also the problem of outdated encryption tools and outdated computer programs. There are, as Kay pointed out, a lot of mom and pop corporations out there, and there are also a lot of small law firms that don't like to spend that kind of money to continuously every 6 months upgrade all of their programs, their software, their hardware, in order to take advantage of all of the latest security protections. So one of the things that we have to be particularly careful of is mobile devices. And I'll push our next slide out to us. Lawyers are addicted to their smartphones and laptops. I have been told that I wouldn't be able to breathe without my smartphone, and I disagree with that, but nonetheless, lawyers use laptops, tablets, smartphones, etc. for almost everything that they do. And for a growing number of lawyers, these devices are the only computers that they use for client matters. So the problem is that many of these devices can be hacked to steal contact lists, usernames, passwords, data, private data about the client, and in the case of witnesses, communications back and forth on strategy about the case. Also, browser history can be looked at. One of the articles that I read reported that more than 10,000 laptops are reported lost every week at 36 of the largest United States airports. And these losses typically happen at security checkpoints.
Or when you get off the plane and leave it in the seat in front of you.
Despite the fact that they always tell you not to leave anything behind, none of us ever listen to that. And so I put together just a few ideas of things that attorneys can do to help protect confidential information when they're using their mobile devices. Password protect your devices, obviously. Our IT guys reminded me that you can also password protect every document that you send as well, in addition to password protecting your device, and also use encryption tools when communicating any privileged information. In fact, it should probably just become routine to use encryption tools no matter what you're communicating back and forth to your client or to your witness. They also suggested creating and storing electronic documents only on the firm's network rather than on your home network. They felt that that was safer. Now, the IT guys talked to me about scrubbing metadata. That's a little bit beyond my technical capabilities to fully understand, but they assured me that it's not a difficult thing to configure your computers to do. And they suggested scrubbing that metadata before documents are sent to any external email address, including the lawyer's home email address. So if you send yourself documents at home so that you can work on them, you should scrub the metadata and also, of course, use encryption. Avoiding installing third-party mobile applications. I mean, there's an app for everything these days. And using apps on firm-issued smartphones apparently has a significant risk in that they can spread malware, they can actually insert viruses that can infiltrate a network, and allow much more open access to data. So we want to be careful about the apps that we download to our company phones or our firm phones. And we want to advise our clients of the same thing. If they have 8,000 apps on their smartphone and they're calling you or texting you or emailing you with confidential information from that smartphone, we want to advise the clients to be a little bit careful with that. Also, we can put Bluetooth devices in non-discoverable mode, and we can advise our clients to do the same thing. And we can password protect and encrypt our flash drives. Doing those things are just a few things that you can do to show some due diligence that you've made the effort to continue to protect the privilege. What about wireless systems? Everybody loves their wireless connection. I know I love mine. And often institutions, law firms, companies, even at home, we create wireless networks that allow us to access the internet and all of the firm's stored data from anywhere in the firm without necessarily requiring a wired connection. The signals travel great distances, and sometimes with fairly unsophisticated equipment, they can be picked up from relatively far away, especially if the firm is a smaller firm and using a general off-the-shelf system without changing any of the system settings or using any type of encryption. And so in addition to that, a lot of businesses frequented by lawyers have Wi-Fi networks. How many of you have ever worked from a Starbucks or from an airport or a hotel? Airports provide internet access, typically at no charge, sometimes for a small fee. But the transmissions between the laptop and the base station are not encrypted in these hotspots. and so that can become an issue. Public computers is another issue. A lot of lawyers gain access to their office email by using browsers on computers that are accessible to third parties. We often work in hotels, airports, sometimes in the office of the client or of another lawyer. And so unless proper precautions are taken, anyone who uses the computer after the lawyer may be able to gain access to that lawyer's email. And so the solution to that is relatively simple in that they can exit or log off at the end of the session, and they can close the browser. Both of these might be necessary to clear the password and any browser pages. Now, if there is key logging software on the public computer, there's not a lot that an attorney can do once all of the information has been key logged. Do you all know what key logging is?
I'll say no.
Okay.
Because the audience can't respond, but no.
Right. And it was mostly a rhetorical question because I was going to explain it.
Okay, good.
But the risk of key logging, hardware and software, these are programs that can be placed on any computer really, but typically they seem to be placed on public computers, and they allow a third party to capture the keystrokes of the user on the computer and can compromise the security of passwords, client confidences, and other types of matters like that. And there's really little that can be done to protect against the risk, so generally lawyers should just be cautious when they're using publicly accessible computers and to discuss the same risks with the client. Don't allow the client to be just using the hotel computer to discuss confidential information or access protected information.
That's just, again, something you have to keep in mind, the sophistication of the client, the attorney witness, I mean, not attorney, but the corporation's witness. These are all details that have to be, not only do you have to instruct them, but it needs to be reinforced on a regular basis.
I think that's very true. And the other thing that I run into a lot with my clients, and at first I was kind of averse to texting, but I've gotten used to it now, and texting and instant messaging. We're seeing an awful lot more of that now. And generally speaking, the malpractice insurers suggest that you do not use text and instant message concerning client matters. But in addition to that, there are a lot of other reasons not to communicate with your clients via text and instant message. I mean, first of all, obviously, it's not as secure. They don't have the encryption technology on text and instant messages that they have for general emails available. But also, texts are the most informal types of communications. They're prone to errors in spelling and word substitutions by the programming. And according to one insurer, they can become a smoking gun in a malpractice suit. They're also more subject to hacking and interception and misdirection. If the device is lost, generally the instant messages and the text are fairly easily accessible. And then finally, text and instant messages are generally inappropriate for client and business communication because preserving a record of them can be much more difficult. It can be time-consuming and expensive. So text and instant messages are a really good subject upon which to educate your clients to help preserve the privilege.
I have a client, and he will only communicate with me through text. I send him emails. He does not read them. So to protect myself, I have to text myself and him and email it to myself.
And that's something that we're finding more and more is that's one of the challenges that's presented to us because clients are expecting us to communicate in these other forms, and they're not really appreciating the damage that it could potentially do to the attorney-client privilege. But what I've done here to wrap this portion of it up is just to give you a list of some ideas to help protect confidential information and preserve the privilege. This isn't an all-inclusive list by any means. It's just some general ideas that you or your firms may wish to adopt. First of all, creating a confidentiality policy and circulating it regularly. Some sources even suggested to me that naming an attorney manager of confidential information would be a good thing, and that person would head up the policy, the changes to the policy, and also training all of the attorneys and staff. And I suppose depending on the size of your firm, that could be very helpful. The firm should adopt policies to address text and instant messaging and all other types of internet communications. The firm should conduct a risk assessment of all of their devices, everything that's out there that the attorneys are using, and assess the sufficiency of whatever the current safeguards are on it and upgrade those as necessary. Firms should require passwords, especially for portable electronic devices. And they can also configure both desktop and portable devices to lock after a defined period of time. And they can configure portable devices to permit the firm to wipe the data if the device is lost or stolen. That can be particularly helpful. The IT guys told me that there are tracking devices available that can report a laptop's location once it's connected to the internet. And they suggested, obviously, encrypting all personal information and protected information sent from or stored on any electronic device, whether it's home or portable or work. And they said also one of the things that they run into frequently, again, often with small businesses, small firms, clients who are unsophisticated, is that their existing firewalls and antivirus software are not the latest and the greatest, and so that does provide a level of risk there. And so with that, I turn it back over to Kay to decide where we're going next.
All right, thanks. I was just, again, I look at these and I think let's apply it back to our corporate witness. And again, if the client is not a big Fortune 500 company, mom and pop, single, solo practitioner, something like that, you're not going to necessarily have a designated phone or computer only for business. I mean, I know I use mine for multiple purposes, but I'm thinking of the situation where the corporate witness shares a cell phone with the spouse or the kids. And you have, if you have text messages, which I realize are not recommended, there are other people who are going to have access to it. And again, the problem that you have is educating them, but you have to keep in mind what their limitations are on this kind of thing. So I'm going to talk about social media, and one of the first things I thought was important is, we haven't been able to tell you exactly what happens in your state. That's something that you each will have to go out and look into. What does your state say about Upjohn? What does your state say about former employees? Is there a privilege for them? My state, Louisiana, says no, there's not. So that gives me just an added layer of preparation I have to do when I'm dealing with these people. But one of the things I know we've all seen it, and I want you to picture that television commercial or the football game where the guy's going in and reaching for the touchdown and it's in like slow motion. Have you ever, well, not have you ever, but how many of you answer to yourself, sent that email, and if you'll notice the slide that's up now, it says to Joe Clinton from attorney regarding red versus blue. Starts out, Dear Joe Client, because it happens that Joe Client's name is right above Joe Clinton in your address book. And the person pushes Joe Clinton instead of Joe Client. You're going to have to, those things happen. What does your state say about an inadvertent disclosure that could take place in this situation? It's an email communication, And this one says, Dear Joe Client, this is a confidential email, see attached work product. The problem that we have here is that the attorney-client privilege is very much tied to the attorney work product. And when you waive one, you run a big risk of waiving both. So in this situation, I mean, this could happen because you've got the Joe Clinton is right below the Joe Client in your address book. The paralegal accidentally pushes Joe Clinton instead of Joe Client, or the corporate witness is trying to send an email to you, the attorney, and they put the wrong name in. That's something that you've all got to be aware of and talk to your client about. And I have heard of situations, and in fact been involved in one, where the client, and then remember, the client normally it's the client who waives the privilege, was actually the one who allowed the other side's counsel to go in and look at documents. I was not involved in it, and they said, sure, come on in. When I got a copy of what they had to let them copy about, 2 months later, I'm looking through it, and I went, wow, this sure looks like some attorney-client privilege information here. It's report letters from an attorney to the client. That was a year-long battle, but because it was the client's privilege to waive, I was able to win those documents back. But I've titled this one, State Does Matter. You have to know what your state says and how it comes down on a situation like that. What was done, well, you can see the slide. It says, while it depends on the state, attorney-client privilege and work product privilege can be waived by inadvertent disclosures to opposing parties, or you can send it to just the wrong person and it would somehow, get out. So 3 schools of thought, obviously. One is any disclosure waives the privilege. What does your state say? An attorney cannot waive the privilege as it's not theirs to waive. Again, what does your state say? My state, Louisiana, one of the states I'm licensed in, says it is the client's privilege, and I didn't have the ability to waive it, although it wasn't me. And then 3, the court will look at the reasonableness of the precautions taken to protect the privilege, and if the disclosure is a result of gross negligence. I mean, if you took no precautions, or if your client took no precautions, then you should be prepared for some problems with that. But that's, again, it's something you need to know what your state says, be prepared, talk to your client about the issues, and your staff, obviously, of trying to make sure you don't give that email to the wrong person.
Also, Kay, I think that there are a couple of things that a firm can do to help protect against that. They can get clawback or snapback agreements or orders, and that can substantially lessen the risk of privilege waiver through this type of inadvertent disclosure. And clawback orders generally should protect the content of a document unless a court finds it specifically not privileged. And so, you can get a clawback order, and it should provide broad and certain protection against waiver based on this type of inadvertent disclosure. But oftentimes we don't get those agreements and or orders, and so in that case, an attorney really has to act very quickly to seek a ruling that privilege wasn't waived by an inadvertent disclosure, don't they?
Right, absolutely. And again, dealing with maybe the not so sophisticated corporate witness, somebody who's, not used to all this, might not even realize that they've done it, or they might be too embarrassed to tell you, oh my gosh, I sent this out to, somebody else. It's something we have to be aware of and talk to our clients about. All right, so who is using social media? I found this very interesting. Facebook, 1.11 billion active users. I bet it's a little higher now, or maybe no, because Facebook stock's going down, isn't it? Twitter, 200 million active users. LinkedIn, I know we're all familiar with LinkedIn, and our clients are probably familiar with LinkedIn as well as Facebook. YouTube, interesting site there. Instagram, 150 million users, definitely becoming more popular, I think. Tumblr, blogging. Law firms have blogs. Corporations have blogs. I think Mr. Dan Wills does a blog. Dan?
Not as often as I'd like, but yes.
And do you do it through your firm?
It's linked to the firm.
Okay, and so what type of safeguards do you go through before you post a blog?
Let's just say I'm careful. I mean, I keep it strictly law-related, and there's a disclaimer, too. This is not legal advice.
Yes.
That's the key, really.
And when we're dealing with our corporate witnesses and our corporate clients, this is something you should be asking them. What type of social media is the corporation engaged in? Does the corporation have a Facebook? Does the corporation have a blog? Talk to the corporate witness. Do they engage in Facebook? Does any of their family members have Facebook? Do they blog? Do they tweet? What do they do? Do you need to know what your witnesses' social media participation is? And if you look at this example here, our chart, it says that between the ages of 0 and 17, only 5% are participating in social networks and online communities. I think that's a low estimate. But lucky for us, I guess, most of our corporate witnesses are not going to be in that age range. They're going to be in the, I would suspect, my experience is at least 45 to 54 to 65 plus. That's a big chunk, but you also need to stop and think they may be involved, but you need to figure out how savvy they are about the use of this social media. Because if they're not really savvy, you could get into some problems with them. Here's another one. The next chart, it gives you just a few different social media types and sites. Again, it goes with the age, and I think that's an important consideration. I've had talking with other attorneys who've talked to me about cases where they were getting ready to put a corporate witness up about a very sensitive subject, and unfortunately this person was not savvy to Facebook. They thought that when they sent this message out, it was only going to a very select few instead of being sent to everybody in the Western Hemisphere and then some. Because of the nature of the post, my attorney friend had to take a reevaluation of whether or not it was worth putting this witness up. So you have to really decide exactly, not only decide, but you have to know what kind of social media they're into and how savvy they are. And again, we've gone over what is the attorney-client privilege, and I just throw it back up there one more time because number 3, communication must relate to fact of which attorney was informed by his client without presence of strangers, for purpose of securing primarily either opinion of law, legal services, or assistance. When you are working with your corporate witness, you need to impress upon them that to maintain the attorney-client privilege, and if you've got one because they are an employee or because you now represent them, that these communications do have to be held not in a family setting or, with the teenage kids running around reading the emails. If they're sharing a computer from the house and they're working on an email to you or sending you something and some kid walks up and reads it, or then it gets posted because the kid is using their cell phone in the background to record something they think is funny, and it turns out to be something very serious. So that's another reason you need to really talk to your clients and explain to them what it is you're trying to do with this attorney-client privilege and how it protects them and the company. All right, so how is it waived? And again, has to be kept in confidence. And we just discussed that some states say the attorney can't waive it, but sometimes they can if it appears that there has been a consent by the client, or if it was so loosey-goosey that, of course, no one would expect to have any type of privacy attached to the communication. And I'm going to push through these slides rather quickly. Attorney-client privilege is waived when client voluntarily reveals the information to another, or his attorney does so with his consent, with the client's consent. And a voluntary disclosure of part of privileged communication is waiver of remainder of privileged communication about the same subject. I've got some cases on that we'll be discussing. But if the client voluntarily reveals the information to another, social media is a great way to get that done. And it's so easy to do because can you really have a reasonable expectation of privacy on social media? And as Amy discussed earlier when we were talking about if you're using communicating with your client through office or company-owned laptops, what's the policy there for emails? Well, what's the policy there for use of social media? If it's the corporation's laptop or computer system, obviously I don't think you're going to be able to expect much in the way of privacy. But in the case of, and Stored Communications Act, I'm going to blow past that one because really that has to do, if you're trying to get the information directly from Facebook or one of the social media owned companies, a little more difficult. But you can go to the person, you can go to the opposing counsel, you can submit discovery, written discovery, and I can tell you now when I get a new case in, one of the first things I do is, okay, who's going to stalk for this person for me on, Facebook, and by that I mean who's going to go to see if they have a Facebook page, if it's protected. I think all the attorneys here know that the Facebook pages are a great source of information on helping you with the defense of your case or the prosecution of your case, because sometimes what's being pled in the pleading is not exactly what's happening in the person's life. But the courts have generally taken the position that if you're posting on Facebook or social media, there really is no expectation of privacy. In EEOC versus Simply Storage Management, an Indiana case, the court held that content on social media sites are not shielded from discovery simply because the information is locked from public view or is private. And some people make that mistake. They think that because they're not putting it on their general timeline or it's not their public part of Facebook, it's for their friends only part, the private part that you can only be invited into, that there is an expectation of privacy. By the nature of Facebook, according to McMillan v. Hummingbird, nobody, a social network by the terminology, social network, you're not going to have a privilege of privacy. So, and I highly recommend that you go and read McMillan v. Hummingbird Speedway. Go ahead and look to see what your state says about it. This case, Largent v. Reed, Pennsylvania court held that no general privacy privilege protected plaintiff's Facebook material from discovery. This was a woman. Largent was claiming she'd been injured. She had multiple injuries. She couldn't enjoy life. She couldn't do this. She couldn't do that. But a little look at her Facebook postings told a different story. And the argument there was, hey, I wasn't putting it out for everyone. I was putting it for my friends to see, so this should be privileged and private. The court here said no. Of course it wasn't privileged and private. It was very discoverable. So, again, let me relate that to your corporate witness. Let's say your corporate witness has to come in and present a certain image and has a certain story to tell. Our corporation always does this. Our corporation did that. Our corporation was very careful about this. But on the Facebook postings, this man's not acting, or this woman is not acting in conformity with what he said he learned through the corporation or how the corporation conducted itself. There could be pictures from an office party on the Facebook page. You need to ask about those things, because if they're up there, they're going to be discoverable. And again, this would be a perfect seminar for any corporation, for their employees. Don't go to your Christmas party and act a fool, as we say here in the South, because if it gets posted online, it's going to be there forever and it will be discoverable. Another thing you should educate your client and the corporate witness about is the ability to have their photos tagged by someone else. I've asked that my family not do that, but I have a sister who won't listen to me. So, all right, then what is on social media is discoverable. We just talked about that. Something that you really have to, I don't think there's a way to enforce enough how strongly people should be made aware that once it's out there, it's always out there. I live in New Orleans. In fact, I live in the French Quarter. And people come here, and we're known as the Big Easy. We are very friendly, but people will do things on Bourbon Street for plastic beads that I'm always amazed at, and this is the age of the cell phone camera. That's going to be put online, and if someone sees their picture, they have no recourse. What are they going to say? I didn't know I was standing in the middle of Bourbon Street with 1,000 people taking my picture? Yes, I think you would. You have no expectation of privacy on that. So it's going to be discoverable. It could be inadvertent, or maybe they didn't do it, but still it's going to be out there. And I would certainly ask for those kind of things when I am conducting discovery. Examples of attorney-client privilege being waived through actions on social media. All right. Office computers, I think we covered that pretty well. In this case, Scott v. Beth Israel Medical Center Incorporated, Scott was a doctor who was planning to leave his employer, Beth Israel, and he was planning to sue them. And here again we have an instance of the employee using the office computer to talk to his attorney. Number one, attorneys, you need to talk to your corporate witness, as we discussed earlier, and make sure that you are not communicating over someone else's network that's going to be sucked up and stored on their server. You need to find out if they have a policy for that kind of thing at the new employee's site, if it's a former employee. If they're using social media while they're there, checking their Facebook pages, checking the wives, the friends' Facebook pages, that's all going to be stored and can potentially be there to come back and haunt them. Same thing for a former employee. People use their office computers for social media. Again, you have to know what your corporate witness is into, how knowledgeable they are about the social media. And here again, we're talking about Stengart. That was a really fascinating case, and it had to do with email and electronic communications. The court said that email exchanges are covered by the attorney-client privilege like any other form of communication, and that, as Amy said, was a New Jersey case. And I think you need to compare the Stengart case with the Scott case, because it makes a difference for your corporate representative, again, if they are using their web-based email address, deleting it, making sure it doesn't get saved on the company's server with a different location now. And I highly recommend that you know what your state's position is on emails and the expectation of privacy. What is the policy? What's the policy of the corporation? What's the policy of the new corporation? If it's an individual who is simply you've hired as a consultant, what type of expectation do you have there? Blogging, very, very, very popular. Just talked to Dan about the blogging. I've been asked to do a blog. Again, you have to be careful about what you're saying, and if you're working with your corporate representative, make sure they're not blogging about what it is you're doing. Here, a California court found that there was a waiver of attorney-client privilege when the client was posting about the legal strategy and conversations with an attorney on her blog. She discussed it in GChat, email conversations, Lens v. Universal Music Corporation out of Northern California. Very good case to read. Again, because she put the conversations online that she was having with her attorneys and they were talking about the strategy, she was disclosing all of it. Again, that's where you need to talk to your corporate witness and impress upon them, look, you can't go talk about this. Don't post it on Facebook. Don't write about it in your blog. Don't upload. Let's say you did you filmed a practice deposition, and you gave it to him to go home and look at, and just take a look at this and see what you think. Please. Tell them, do not upload it to YouTube to share with their family and friends and think that that's not going to be discovered. Not a good idea. In fact, it will blow the attorney-client privilege for you. Here again, a different one. This is Quintero v. Convivio, and I think this is a great case and would highly recommend that you go and take a look at it. This is in Southern California. Fight between competing website companies. And the fact that this was an inadvertent disclosure, a CD was turned over. They were able to get the CD back because they argued, well, the attorney said, I asked this employee to put this together for me in anticipation of litigation. The problem they had is they blogged about it. They put it on their website. That's another thing you have to know. What does your corporation have on their website? Do they have little chats where people can come in and make comments? You need to know that. You need to know if there's been any bad comments about your corporate witness. So take a look at Quintero v. Convio and the fact that they disclosed the most important part, which was, hey, we've got affidavits that say they were wrong. The court said, well, seriously, do you think that you can disclose the most important part of the strategy and think that the rest of it won't come out? Clearly, that would not be a very reasonable expectation for privacy. So you need to counsel your clients about blogging and their websites. Here goes along with one of Dan's comments on whether the employee is covered by the attorney-client privilege. And it said even in subject matter that a lower echelon employee could be covered. In this instance, it was an investigator, employee of the firm, who went out and blogged and talked about what was going on, talked about their strategy and her conversations with people. Bad look. Again, you have to impress upon your corporate representative you can't be discussing what we're doing. That was an interesting case because it involved Howard K. Stern, not the radio Stern. Another, I think a good case to look at is the electroscientific case, which is a patent infringement case. which the defendant asserted attorney-client privilege with respect to a letter from his attorney. But again, they put it in a news release. You can't do it. And here again it says a sophisticated, well-counseled party who intentionally discloses an important part of an otherwise privileged communication acts in a manner that is thoroughly inconsistent with preserving the confidentiality of that communication. You absolutely have to know whether your client would be considered someone who's sophisticated. Have you done enough to inform them? Have you done all that you can do to make sure that they understand the privilege that's going to be waived? And real quick, we're almost out of time. Something attorneys need to be careful of. Not only can you waive the privilege, you can put yourself in a position where you're going to be in a lot of trouble. An Illinois attorney is facing disciplinary action after responding to a client's negative review on an attorney review site by revealing confidential information. You simply can't do it. Do not even think about it. Won't be good for you. We had a case here in New Orleans where the U.S. attorney, a couple of his top attorneys were blogging. They were doing it under a pseudonym, but unfortunately not clever enough. They got found out. It got traced back to them because you know what? There are people out there who can figure out who you are just by by the writing. And unfortunately, not only did they have to leave, so did the U.S. attorney. He had to resign and move on. It's cost our state literally hundreds of thousands of dollars because cases that these two were involved in are now being retried. So, social media, pitfalls for your client, your representative, and for you. Attorneys we have to hold ourselves up to a higher standard. We have to be aware at all times, and we have to counsel our clients. Don't friend a jury, a judge, or the other parties. Be careful what's said in profiles. Know what the profile is for this attorney, this corporate representative you're about to put up. Disclaimers, they're important, but guess what? They won't cover you completely. Contact information, you got to be careful because sometimes you'll actually upload other people's information. And we are out of time. I enjoyed it. I hope you guys learned something today. I'm sure you had questions, and I'm sorry we didn't get to more of them.
Thank you, Kay. On behalf of LexisNexis, I'd like to thank Kay, Amy, and Dan for an outstanding CLE program today. If you submitted a question that did not get answered today due to our time constraints, please feel free to contact Kay or Amy or Dan using the contact information on the last slide in the deck today. Thank you all, and have a great afternoon.